Welcome to Dementia Care Aware's education series on capacity. My name is Sami Patel, and I'm an attorney working with elder law and advocacy located in San Diego, California. I have been a practicing attorney in Southern California for 15 years. My experience includes professional liability, employment and business law, and various other areas of civil litigation. I've been specializing in the senior community of San Diego since 2023. Elder Law and Advocacy is a nonprofit which provides free civil legal services and Medicare counseling to seniors in San Diego and Imperial counties. Our mission is to protect seniors by providing legal advice and advocacy, helping them defend their legal rights, and preserve their respected place in the community. Our agenda includes introducing some basic principles of legal capacity. We're going to look at those principles and legal standards through an attorney-client case example. And then we're going to take those same principles and apply them to a patient-physician setting. What is capacity? Generally, legal capacity is the ability to make a legally binding decision. Historically, people may have referred to competency when thinking of legal capacity. However, competency is more of an all or nothing term and resulted in too many rights being taken away. Over time, there's been a reform in the legal standards of competency. We are shifting away from using this blanket term of competency, and courts are instead assessing the individual's functional abilities or capacity to perform specific tasks. We are asking, do individuals have the capacity to create an advanced healthcare directive? Or do they have the capacity to create a will or enter into a contract? The law provides standards that we can look to when determining issue-specific capacity functions. It's also important to note that there's a presumption of capacity in the law. A legal presumption is where the burden of proof is on someone else to show that a patient or client lacks capacity. The burden is not on the patient or client to prove that capacity is present. So that's our starting point when an attorney goes into a meeting with a client. You are meant to presume capacity unless you see evidence of the contrary. We'll begin with the case of Maribel. Maribel is an 80-year-old woman at an appointment with a legal services provider to discuss advanced planning documents. She is widowed with 3 adult children and lives with her daughter, Maria, who is her primary caregiver. Maribel uses a walker and has a diagnosis of dementia. Maria made the appointment with Maribel, and Maria provided most of the answers to the intake questions. Maria brought Maribel to the appointment. The attorney asked Maria to step out and met with Maribel alone. The attorney explained the advanced planning documents to Maribel, who listened and nodded yes. At times, she seemed distant during the meeting and may have even nodded off. When the attorney asked Maribel if she had any questions, Maribel said no. What we need to figure out is, does Maribel have sufficient capacity to prepare advanced planning documents? Let's recall our basic understanding of legal capacity. Capacity is the ability to make a decision. There is a move away from the all or nothing idea of competency, and the standard is issue specific. So we're asking, does Maribel have the capacity to create an advanced healthcare directive? There is a presumption of capacity, so that's our starting point. Capacity is a spectrum. You can have capacity to do some things, but not others. Also, legal capacity is fluid. Someone can lack capacity on one day, but have capacity the next. It can change depending on medication, how tired someone is, and a lot of other factors. Finally, capacity is not determined by a diagnosis. For example, dementia does not render a conclusion as to whether or not one has capacity. What is the structure that the law provides? You can find code related to capacity in so many parts of the law: probate, civil, penal code, and so on. But we really get a lot from the probate code, specifically the Due Process and Competence Determinations Act. This is where we can find a lot of those basic principles I mentioned earlier: the presumption of capacity, that a diagnosis does not mean incapacity, and that there must be evidence of deficits, and that those deficits have to significantly impair the specific decision in question. Now let's return back to the case of Maribel. The attorney did not prepare the documents at the first meeting. The attorney met with Maribel a second time, this time in the morning rather than in the afternoon. Maribel spoke clearly about her family and described that Maria was a huge help to her. The attorney explained the advanced healthcare directive to her. Maribel stated she wanted to name her daughter as agent since she's my right hand. Maribel stated that Maria would know the healthcare preferences she would have, but also stated that organ donation would be okay. Maribel said, "I don't need those body parts anymore after I die, so if they can do some good, I would like that." The attorney also asked about life support treatments. Maribel indicated she wanted no such treatments, stating simply, "When it's your time, it's your time." So clearly, this meeting is going very differently than the first did. And this demonstrates the incredible fluidity of capacity. How do we make our judgment call on capacity? Of course, there will be some variation on the meeting depending on the attorney or other circumstances. I believe these guidelines generally follow recommendations from the American Bar Association. The attorney will meet with the client alone. We want to make sure there's no coercion or influence, and we're also preserving the attorney-client relationship. We go into this meeting knowing that the law has a presumption of capacity. Next, we look to the law to see what level of legal capacity is needed for the client's goals. There are various statutes that give us the standards for the level of capacity for various situations and tasks. There's one standard for giving informed consent, another for preparing an advanced healthcare directive, one for making a will, a power of attorney, and so on. Then we're going to look at the deficits, if there are any, and determine whether there's any sort of correlation with the deficits and the person's ability to appreciate the decision that they're making. Using these standards is something you're all very familiar with. You do it with informed consent all the time. You are identifying if there might be any deficits and determining if those deficits are significant. The lawyer is doing the same thing in this meeting, but applying it to slightly different standards at this appointment. I'll move through some different standards very quickly. I wouldn't expect you to know these or have experience with applying them, but I do want to give you a bigger picture of what we're doing in our meetings. You're trying to figure out if deficits significantly impair her understanding of the nature and consequences of her decision, and can she communicate it? This probate code is thinking about proposed healthcare. The capacity to create a durable power of attorney for finances uses the capacity to contract standard. This is a high standard. We would be looking at the person's ability to communicate verbally or by other means the decision they are making, and that they understand and appreciate the rights, duties, and responsibilities created by the decision, the consequences of the decision, and the risk, benefits of the decision, as well as the alternatives to the decision. Again, asking, do any of the deficits that we may see significantly impair this? And what if the client wanted to execute a will? What would she need to be able to show in order to reflect capacity to execute a will? Do her deficits significantly impair her ability to understand what a will is, understand the nature of her property, and know her relations? It's important to note this is a very litigious area, and the attorney who prepared the will can be liable. So documentation of the client's capacity is really key in these situations. And just to note, the critical determination is incapacity at the time of contracting, although evidence of incapacity before or after the time of contracting may provide circumstantial evidence. Back to our judgment call. When talking about capacity, it's also important to think about undue influence. When an individual's capacity is beginning to decline, he or she can become more vulnerable. So that is something for us to look at. Then finally, the last step, we decide what our next action is. Do we need to meet with the client again on another day or time because we think they may have capacity in the morning, like what happened in the case of Maribel? Or do we need to look at some medical expert opinion or evidence, progress notes, because we're not really sure and we want more evidence to support capacity in this situation? Or do we decide there is capacity and we're going to go ahead and move forward with making those documents? So the key takeaway from the case of Maribel, capacity is fluid. The attorney met with her a few times, different days, different times a day. Capacity is not dependent on a diagnosis. Legal standards provide guidance. And in the end, it's a judgment call based on evidence. We're looking to see if there's a correlation with the act or decision and if the deficit significantly impairs the ability to understand and appreciate the decision. What can a medical provider do to help? With or without a diagnosis, documentation is key because it's evidence. It's a piece of the puzzle. The world, lawyers, and especially the court, if it comes to that, may need to know what the impairments are specifically. Were they there when the transaction that's being disputed occurred? And the law especially looks to evidence of specific deficits in the areas that I understand are in your assessments: alertness and attention, information processing, thought processes, and ability to modulate mood and affect. So again, a couple slides back, I mentioned that the attorney might need to gather more evidence to help clarify their capacity evaluation. And your charting, your progress notes, your opinion may become critical in determining whether or not capacity is there. So it is so important to document, document, document. I'd also mentioned previously that knowing that capacity is fluid can help guide the patient to a legal referral, but it can also guide your appointments. Multiple visits, different times of day, different locations if possible. These can all provide a more complete picture of someone's capacity. More evidence, the better. And you can also use the cognitive health assessment trainings on how to conduct screenings and assessments. Our last example will be the case of Mr. Thomas. Mr. Thomas is a 76-year-old and is at his doctor's appointment. He appears not to remember what you spoke about at a previous appointment and is not taking his medications. Mr. Thomas just had a cognitive health assessment and is showing significant impairment. Mr. Thomas's daughter has let you know that his advanced healthcare directive and power of attorney require a statement from a physician in order to become effective. What do you need to do? This is not a question that I can fully answer for you. This is something that you will likely have some institutional policies about, but I can give a little context. Probate Code 811. This is what the law provides, what those specific deficits are, and how they would impair a specific decision. Again, medical opinions can provide evidence of a deficit and correlation between that deficit and the decision or act in question. Here you can see that the statute does go into a little bit more detail for each of these functions. The capacity declaration for a conservatorship application is actually a great cheat sheet that mirrors this language. What I really want to leave you with is a basic understanding that capacity is the ability to make a legally binding decision. It is not all or nothing. It is issue specific, a continuum or a spectrum. It can come and go, and it is not determined by a medical diagnosis. And the most important thing you can do as a medical provider is to document specific deficits. It's been a pleasure presenting the DCA education series on legal capacity. Feel free to reach out to us at Elder Law and Advocacy with any questions you may have. The DCA Warm Line is available for practitioners to explore further questions and topics when needed.